Well, welcome everyone, and thank you for joining us at the 2023 TMCC U.S. Constitution Day Forum. This forum has been in existence at our campus since about 2005 or 2006, required by federal law. We feel bad about that. But once we started doing it, we kind of wondered why we haven't been doing it all along. This is a wonderful opportunity each year for us to examine an aspect of the U.S. Constitution. The amendment was passed in Congress and signed by the president at the time because there was a feeling that in both primary, secondary, and higher education, there was a woeful misunderstanding or ignorance about this document. I think all of you have been in political science for enough weeks to know that in history that we agree. There's a woeful ignorance about this document. So we're looking forward to this opportunity this year to focus on a new topic that we haven't really covered before. We are looking at recent controversial actions and activities surrounding the United States Supreme Court and federal court system, and asking the rhetorical question of whether or not our republic is imperiled by the dramatic events that have been affected at the federal court level. We have an august panel joining us today. We have an okay panel joining us today. Starting to my far right, we have Dr. John Reed, who is a professor of history here at TMCC. To his left, we have Joe Dimitrovich, who teaches for us as a adjunct colleague, has for many years, and he also teaches history and humanities. And then closest to me is Dr. Brian Fletcher, professor of political science. We are kindred spirits, and happy that he is on the panel today. I am Fred Locken. I am the chair of the department, and I am also a professor of political science, and will be moderating this session today. The structure of this is pretty simple. We're going to start with introductory statements by each of our presenters to provide context and background to the topic that's in front of us. We have given them a range. I will monitor the range, so we leave some time for questions from you. So given the topic, I would have you start putting on your thinking caps to come up with questions that you may have. Watch to see if they're included in the comments, but otherwise we'll try to get all of those questions covered during this program. We appreciate the turnout. The sign-in sheets were at the top there. Make sure that you do sign in. There is value to that. And did want to thank the colleagues that have joined us today. We have Dr. John Galtney, who teaches economics for us, also a political scientist, former president of TMCC. We have Dr. Paul Davis, who is a professor of political science and in his 48th year at TMCC, a legend. And then we have Dustin Moore, who is a brand new business tenure track faculty with us in his second year, but had taught for us for an incredible number of years as a part-time colleague, and we really appreciate your support for our program as well. So without further ado, we are beginning with Dr. Reed.
All right, welcome. Thank you all for coming today. I was asked to provide a little bit of historical context, so I'd like to get us started by looking at this issue, but I want to just tell a quick story. This summer, I was watching a television program and a very frightening political event occurred. And the news director in this television show said, "Quick, let's get a historian on camera. He can tell us this all happened before and we're all going to be okay." And I thought that was, it really struck me as funny because that was supposed to be a little bit of a tongue-in-cheek comment, but that is often what the role on cable news that the history professor often provides. No, don't worry about it. This has all happened before. I'm here to tell you that this has all happened before, but I'm not sure we're going to be okay. So let's talk about the politicization of the Supreme Court. My perspective on this is I'm not sure the Republic is going to be okay, but I don't see the judicial branch as the problem. In my opinion, from a historical perspective, it seems to me that it's working exactly the way it was designed. Now, we don't want to do a deep dive on separation of powers theory here, but I say that, and then I'm about to. But in essence, the founders were really influenced by Republican theory, not associated with that current party by that name, and Montesquieu, one of the preeminent theorists. And Montesquieu was very concerned with the need for a balanced government. And the British government, he said, it was the best one because it was balanced between the classes. But when the United States was going to form, they were going to get rid of that class basis. They were getting rid of monarchy, and they were getting rid of aristocracy. So Montesquieu and a couple other theorists said, well, let's have a tripartite divide based on governance. And that's where we get that three branches: executive, legislative, judicial. Judicial branch in the British system is under the executive branch, which makes a lot of sense, because is that not what the branch does? It executes laws, right? But so that is where that branch gets divided out, but it provided an opportunity to put an interesting check on the other two branches. And that check is where the balance comes from, and that's exactly what the framers did. Now, at the convention, they set up the check of the Supreme Court and the federal courts in two ways, and I think that, well, we've learned a lot about it recently, haven't we? But still, I think a lot of the public doesn't quite understand this. But that is a really crucial check, and the check is the appointment power, right? The executive appoints, and the Senate confirms. And that's the only way somebody gets into the federal courts. Now, that is really important for today's topic, I think, because that is inherently a political process. It is built into the system, in my opinion. The president is elected by the people as a whole, as they conceived it in Philadelphia, and the Senate, as they conceived it in Philadelphia, represents the states. Of course, that's changed now, but that was the original conception. So they appoint the federal judges, and so that is inherently political. Now let's look at the history briefly here. I'm just going to do the early history, and then Joe will take it over a little bit here. But let's look at the first president, George Washington. Can we all agree the least partisan president in American history, right? Do we all agree on that? You don't have to nod. They don't agree. Okay, fine. I see the audience. The audience, for those of you on camera, the entire audience agreed with me. All right, fine. I say that because, as you may know, in his farewell address, right, he went on well, I wouldn't say it was a screed, but he really warned the nation about the danger of partisan politics. He said that this is one of the biggest dangers the nation faces. But let's look at what Washington did. He appointed the first Supreme Court justices. Who did he appoint? Fellow Federalists, people who agreed with him on the view of the way the Constitution should be interpreted. And he distributed them geographically, right? And so that is a political choice as well. So the first president, the least partisan, made political choices. And I would argue that is actually a healthy way to do it. As I looked online, I was Googling, as 21st century people do, about, what are people upset about, the politicization of the courts. I don't see a problem. And and I saw a lot of people are concerned, apparently. A lot of them seem to be concerned with, well, the outcomes aren't going the way they want them to go. But in a republic, that's the way it has to work. If you have in my opinion, if you have one party rule, that's not a democracy, that's not a republic, that's an oligarchy. So the fact that you disagree with some Supreme Court decisions, you agree with some, I think that's part of being a republic, and that is actually a healthy process and actually built into the system. Let's look at the next major figure in the Supreme Court history, John Marshall and the Marshall Court. Now, of course, many of you are familiar with this. In my class, we haven't got here yet, but we'll be looking at this concept of judicial review. And in the question and answer, we can go into a deep dive on any of these things. But just as an overview, we often talk about Marshall creating the modern Supreme Court and particularly formalizing the judicial review process in Marbury versus Madison. But we often forget that Marshall himself, in the pantheon of American founders now, was a firm and solid Federalist who was appointed by a Federalist president. And the Marbury decision itself was a politically minded decision. The way it was handed out was, it had awareness that the new president would be extremely hostile to the decision, and so the decision was put forward in a way that tied Jefferson's hands to do anything about it. So I think that in some cases, Americans today expect to see some, or they believe there's some halcyon past where the proper way to judge the Constitution was handed down from on high to human beings. And that's just simply not the case. Judicial interpretation itself is a political act. And it can never, in my opinion, be separated from politics. Where you're going to have a problem with politicization is if people stop paying attention to elections. And that's where I think the danger to the republic lies, not in the current Supreme Court. Let's talk about more politicization. How about the impeachment trial of Samuel Chase, 1803? This was one of the first major impeachment trial, and it set the precedent for how impeachments would be handled at the federal level. Why was the Supreme Court Justice Chase impeached, you ask? He was impeached because from the bench he began making political statements against Thomas Jefferson and the Jeffersonians during the election. So, I mean, you shouldn't do that. I mean, that's terrible, right? I mean, he was a rabid partisan. The 1790s was one of the most rabid partisan eras in American history, I would say comparable to today. So it has happened before. We've been able to survive it. And from the bench, he's instructing the jury on the law. You know, it's like, well, I don't remember what the case was, but you know, to find insanity, the person has to not know the difference between right and wrong. And by the way, Thomas Jefferson is a danger to society. I mean, what the hell? I mean, that's nuts, right? That's not professional. He also, and this gets a little bit complicated, but justices used to have to go on the circuit, and they would perform the role of district judges, so he actually oversaw trials. He oversaw a sedition trial against a Jeffersonian journalist, and in that trial, he constantly interrupted the defense attorneys. He more than intimated to the jury that he thought the guy was guilty of sedition, to the point where all the defense attorneys quit, because it's like, this judge is just impossible. He was a horrible judge. He was using it for partisan purposes. I don't approve of that. It's horrible. I think it's very wrong. He was impeached for it. He was not convicted, though, and so that set a precedent that the state for impeachment would have to be a very high level. But my larger point is that rabid politics has been, well, politics is embedded in this system by design, and it is healthy. Hyper-politics, hyper-factionalism erupts periodically in American history, and that causes lots of problems. That's the problem. 1790s, 1850s, 2010s, all of those have kind of been reflected into the judicial branch, but that's not the problem, in my opinion. The problem is that the tensions that are behind that hyper-partisanship. And then let's just finish with the Taney Court. Let's jump up to the 1850s when the Taney Court ruled in the Dred Scott decision, a decision that's complicated we won't go into here, but perhaps the most controversial decision in Supreme Court history, highly politically motivated. President Buchanan actually contacted two of the Supreme Court justices and asked them to make this decision and hurry up with it before he took office. So this idea that the judges are separate from politics is just simply not true. I would argue, though, it's built into the system. It's healthy if the system is healthy, and that is the problem. So where the judicial branch is fine, in my opinion. You don't like their decisions, wait 10 years or 15 years, and it'll come back around the other way. That's fine, but is the republic going to be okay? I don't know. Will people start paying attention to the results of elections? I think that's the true danger. And I will hand the rest of my time to my colleague, Professor Dimitrovich.
Thank you. Excuse me. Thank you. During John's talk, I was reminded of a comment by, it was either Sam Clemens or Mark Twain, I forget which, but where he said, history doesn't repeat itself, but sometimes it rhymes. I have a two-part talk. First part is on the court packing or court reform, depending on your point of view, of Franklin Roosevelt, and then the Warren Court. 1936. And this is relevant because recently there's been talk of adding more judges to the Supreme Court. So history rhyming. But in 1936, Franklin Roosevelt won a humongous victory. And he expected things to go just like they did in his first term. First term, he bent Congress to his will, and the people backed him. This is during the Great Depression. So he thought, okay, this is going to go on. But it's not. His second term is not going to be like that. And the main obstacle standing in his way, as he saw it, of improving the condition of the American people was the Supreme Court. He had come out a couple times in his first term with negative comments about the court, and he said that in his campaign in 1932, he said, the Republican Party controls all three branches of government. He saw it as a political institution, the Supreme Court, judicial branch. But people didn't like that. Most people like to think of the court as above politics. Roosevelt knew it wasn't and still isn't. And he also referred to the court during his first term as the 9 old men. And they were. They were. There were 5 in their 70s and 80s. The youngster on the court was a mere child of 62. So they were old. And the court was divided into 3 groups. Politically, you had the 4 horsemen of the apocalypse. 4 very conservative Supreme Court justices who thought it was written in stone. They probably would have felt a mistake the framers made was providing for an amendment process. And it can't be interpreted. Their average age was like 74. And there were the 3 musketeers, 3 liberals. They were much younger. Their average age was only 71. And 2, including Chief Justice Charles Evans Hughes, who tended to side with the conservatives. And during Roosevelt's first term, near the end of his first term, they declared several New Deal pieces of legislation unconstitutional. And that bothered Roosevelt, but he thought, okay, we'll wait till after the election. And he wins again in a landslide, and that emboldened him. He's going to move. And his Attorney General, Homer Cummings, showed him a proposal written to reinvigorate the court. And it called for the president and the Senate to put in new federal judges for any who turned 70 and didn't resign. Roosevelt loved irony. And the irony of this proposal was written in 1913 by a man by the name of Reynolds, who was one of the 4 horsemen of the apocalypse. He was Attorney General in 1913. So let's use this. And how can they object? So 2 weeks after he was inaugurated, this is in February of 1937, he and his Attorney General put this forth to Democratic congressional leaders and to the cabinet. Got a very tepid reception. Again, you're politicizing the Supreme Court. But he goes on with it, and they present it as a bill in Congress, and he's not surprised by the opposition of the conservative groups like Chamber of Commerce and National Association of Manufacturers, but he's really surprised, Roosevelt is, by the grassroots opposition. He miscalculated the feeling of the people toward the court. The people, it's above politics, and he's putting politics into it. And there were some liberal, independent liberal senators who opposed this. But he goes on, and the opposition increases. One liberal Democratic senator said no liberal cause was ever won by stacking the deck or packing a court. Roosevelt, in his first inaugural, had said the nation is on a rendezvous with destiny. One liberal Democratic senator gave a speech. He said, if this goes through, constitutional government in the United States is on a rendezvous with death. And this really bothered Roosevelt, but he kept going. And the court decided, through the Chief Justice, Charles Evans Hughes, to emerge from its traditional cloister. And the Chief Justice invited a senator over to his house, which would never happen today probably, and showed him a letter that Justice Hughes had written. And in the letter, Hughes rebuffed everything that Roosevelt said. See, Roosevelt said this is court reform. The justices are too old. They're falling behind. They can't keep up with their workload. And Hughes used statistics, must have been a baseball fan using statistics, right? But he used statistics to show that Supreme Court was the most up on its docket of any federal court. And Hughes said, if we add more justices, all that's going to do is slow things down. And he asked the senator, get this publicity. And the senator had it read before the Senate Judiciary Committee and before the full Senate, and basically it crippled the court reform plan. But to coin a phrase, the times they were a-changin'. I just made that up. And most of them have no idea, right? Yeah. But anyway, oh well. Yeah. The court on March 29th of 1937 reversed itself and ruled several New Deal pieces of legislation constitutional, including a minimum wage for women and children, maximum hours for women and children, the Wagner Act for labor, and the biggie that Roosevelt was really worried about, they ruled Social Security constitutional. And so was Roosevelt, was he cowering the court? Was he, with this threat, getting them to change? And then, shortly after that, one of the four horsemen, Justice Vandevanter, announced he was going to resign. That's all they needed, that one, because they could appoint a liberal. But Roosevelt wouldn't back down. He had won, but I don't know, his pride got in the way. He should have demanded the Democrats withdraw the bill, the reform bill, as he called it. But he wouldn't. And eventually the Judiciary Committee in the Senate, which is overwhelmingly Democratic, reported the bill unfavorably. The Senate, overwhelmingly Democratic, defeated the bill 70-20. It's a major defeat. But Roosevelt, you know, he got what he wanted. The court was expanding its interpretation of the Interstate Commerce Clause and ruling these bills constitutional. And because of the fact that they were 9 old men, death and retirement is going to enable Roosevelt to appoint a Chief Justice and 8 Associate Justices. So he completely redid the court. And I've always said, maybe being a justice of the Supreme Court is the job to have, because when you get it, your life expectancy goes up by about 25 years. They live forever. The average life expectancy is like 127. And not far off, probably. But he's getting what he wanted. But what was the price? What was the price? And there is a price to be paid for this. And a newly elected congressperson, elected in '36, from Texas, said Roosevelt's miscalculation of the people and of the Congress caused the formation of a Republican and Southern Democratic coalition, which is going to be a cross to be borne by every Democratic president for the next 40 years, including that congressman from Texas, a guy by the name of Lyndon Johnson. So Roosevelt, it is political, as John said, and Roosevelt understood that, but the people didn't. It's one of the few cases where he was too far ahead of the people, maybe. The second part of my talk is on the Warren Court, 1953 to 69. A colleague of mine, when I taught back at Ohio University, Jim Jordan, not to be confused with the other Jim Jordan, he said Supreme Court never has any easy cases. They get handled long before. And he said the court has impossible decisions because they are constantly have to choose between rights of the individual and rights of the group. No court before or since in our history has come down more on the side of the rights of the individual than the Earl Warren Court. Early on, 1954, his second year as Chief Justice, Brown v. the Board of Education of Topeka, Kansas. In 1896, the Supreme Court had ruled in Plessy v. Ferguson that you could have segregation, separate facilities, they had to be equal, separate but equal. This was in sleeping cars, but it established a precedent. It was still in effect. Every school in the country practically in the 1950s was segregated, black and white, either de facto or by law. Case gets to the Supreme Court, they decide to hear it, Brown v. the board. The court ruled unanimously, brilliant by Warren to get that to happen, but unanimously that separate but equal had no place in public education, that separate cannot be equal. And ordered the desegregation of all schools, but they put a phrase in there, with all deliberate speed. Well, with all slow speed. Me as a track runner. Anyway, it's going to be years and years before most southern states start desegregating their schools. The Warren Court did more on civil liberties than any court in our history. And Warren is a former prosecutor, but he wanted to end police abuses. And there are several cases that he used in this regard. There was Reynolds v. Sims. This is where the Supreme Court ruled that evidence obtained illegally cannot be used at trial. And they used the Fourth Amendment. If you watch Law and Order and those kind of shows, you're so familiar with the Warren Court's decisions. And well, before that, Gideon v. Wainwright, where the court ruled that everyone, in spite of their income, is due process. And everyone, in spite of their income, is allowed representation. And this is the beginning, by the way, of the creation of the offices of public defender, was from Gideon v. Wainwright. The case that is most loved or hated is the Miranda v. Arizona, where the court ruled that police have to tell people what their rights are, have to tell people, you have right to an attorney. If you can't afford one, one will be provided for you. Everything you say can and will be used against you in a court of law. You have the right not to say anything. Police carry little cards, Miranda cards now. And they have to read those. There were other cases. There was Engel v. Vital, not Dick. Engel v. Vital. Right. Hey, you got to be a sports fan. The court ruled, this has been called the, you took up some of our time. The court ruled that yes, 7 minutes. That's right. Anyway, the court ruled that students in public schools cannot be forced to take part in religious exercises or even have to observe religious exercises. The Supreme Court ruled that our congressional districts were all wrong. Rural districts had too much control. Urban were underrepresented. They came up one man, one vote. There are only two offices, by the way, in the United States where that doesn't apply. What are they, people? President and vice president. The only two. So the Warren Court, its decisions are so far-reaching. And again, no court in our history has come down more on the side of the individual. Thank you.
Thanks, everyone, for coming. I want to thank both my colleagues. I think they did a really nice job of giving us some of the history of the politicization of the court. I'm going to add to that with some current examples and some political science research, and then I'm going to talk about a potential for reforms of the court. So I think a lot of Americans actually think that the court is apolitical. That's something that Professor Dimitrovich was talking a little bit about. Judges will actually try and encourage that view of the court, when John Roberts was in his confirmation hearings, he's now the Chief Justice, he compared himself to an umpire. He said, I just call balls and strikes. And recently, several Supreme Court justices have come out and said, look, we're not political. We're just trying to apply the law. That's not the view that most political scientists have. The saying in political science is that they are politicians in black robes. That's the view that most political scientists have about it. And I think that my colleagues have done a really good job of illustrating that with some historical examples. I thought I would give you some current examples of this. One current example is that political scientists have examined the rulings of judges and found that there's a striking relationship between the outcomes of those rulings and the leanings of the president that appointed them. That suggests that there's a relationship there. That's something that Professor Reed wasn't all that concerned about. He said that that's built into the system. That said, it does suggest that the judges are fairly political. Members of Congress know that judges are political. If they thought that judges just called balls and strikes, then when Antonin Scalia died, Mitch McConnell would have allowed Barack Obama's nominee, Merrick Garland, to have hearings. He said, no, we're going to wait and see what the next president decides. And that is because he is aware of how political the court is. And just to add another example, when Ruth Bader Ginsburg unexpectedly dies, he says, we are going to go ahead and rush through a nominee because we know that'll make a difference in terms of the outcome on the court. And in fact, it did make a huge outcome. The justice that was appointed was Amy Coney Barrett, and she turned out to be the 5th vote for overturning Roe versus Wade. Another illustration that the politics of the courts is even though the judges themselves will say they're apolitical, their retirement patterns suggest otherwise. To talk a little bit more about that, Republican-appointed judges usually retire when a Republican is president because they want to be replaced by a Republican. The same thing is true with Democrats. Now, there are a couple of exceptions in recent American history, but they're pretty easily explainable. So 2 justices that were appointed by Republicans, David Stewart and John Paul Stevens, had become very liberal over their course on the court. And they actually wanted to be replaced by a Democratic president. And so they chose to retire when you did have a Democratic president. The other exception is someone named Thurgood Marshall. He was a liberal lion on the court, and his health was failing. He knew how political the court was, though. He was concerned that he was going to die and be replaced by a conservative justice because his health was failing under George H. Bush's presidency. And he actually told his clerks that if he should happen to die, that they should prop him up and keep him voting. That said, his health got to such a point that he couldn't stay on the court any longer. He did choose to retire, and then he was replaced by pretty much his ideological opposite, a guy named Clarence Thomas. So just to kind of give a little bit more depth to what both professors previously talked about, the court is very political, and it's something that I think that students should be aware of. Again, the saying is, they're politicians in black robes. Now, Professor Reed talked quite a bit about how the framers looked at Montesquieu when they were trying to design the system. And I think that if we were redesigning the system in 2023, we would draw on Montesquieu. That said, I don't think there's any way, shape, or form that we would use the current court as our model. And I thought I would talk a little bit about that. And up until the 1970s, the average length of a Supreme Court justice's term was 15 years. Since then, it's actually increased to 26 years. And that is likely to increase even more over the coming decades because several of the recent appointments are very young. In fact, it's basically gotten to the point that if you're past the age of 55, you're no longer really eligible to be a Supreme Court justice because presidents want to have someone who's going to be on the court for 3 decades. That seems to me absolutely crazy. And I don't think the framers, when they were designing the third branch of government, would have envisioned a system where you would have members be in office for 26 years. That just seems antithetical to a lot of their other purposes. Another way I can sort of illustrate that I think there's no way we would use this as the basis of our third branch of government is every other constitutional democracy on the face of the planet has rejected it. They think it's crazy. They all either have term limits or age maximums. We're the only ones that allow for federal judges to be appointed for life and not worry about a maximum age. And it's not just other democracies that have made this choice as well. The states have also moved in this direction as well. Normally, when the states are trying to develop their constitutions, they use the federal constitution as a guide. They don't do that with respect to the third branch of government. Every single state except for one, Rhode Island, either has specific term limits or they have mandatory ages. So the only place, really, where you have judges serving for life is in Rhode Island and the United States federal court system. It seems to me it's not the way that we would design it. What's a potential reform? Well, there are lots that have been proposed. You've heard Professor Dimitrovich talk about potentially expanding the courts. That's something that some Democrats have advocated for. I think perhaps a simpler reform would be to go ahead and impose term limits. And the one that I am most amenable to is each judge gets an 18-year term. What that would mean is that every president would get 2 selections. I think there would be several advantages of that. One advantage is that you wouldn't have people serving for 20, 30 years, and we can talk more about the potential downsides of that during the question and answer period if you would like. The other is I think it would make the court more democratic, and as Professor Reed pointed out, that's an important feature of the Montesquieuian system that he was describing. Each president would get 2 picks. Right now, if you're president, it's just luck of the draw. Did the judge choose to retire, or did the judge unexpectedly die? And as a result, some presidents get 3 or even more nominees. Some presidents get 1 or fewer. So that seems to be not very democratic, and I think a 18-year term would address some of the problems that we've talked a little bit about. I know we've got a great audience here and an awesome moderator, and so I'm going to conclude my thoughts and turn the mic over to Professor Lockham.
You can keep the mic for questions. Thank you very, very much. First, just an outstanding job explaining a complex issue in an hour-long program is a real challenge. And I wanted to thank all of you for that. Before we go to questions from the audience, would it be possible to outline just a couple of the major controversies right now? Why have the Supreme Court and federal courts become controversial, say, in the last 5 years or 6 years? What sorts of things have happened that weren't expected to happen with the courts?
Well, I'll get us started with an easy one. I think the one is the Dobbs decision, isn't it? I think that the Dobbs decision overturning a precedent of 50 years or so, which the court can do, that seems to have stimulated a lot of concern about the direction of the court, the political process of the court. As Brian said, that decision isn't possible without the maneuverings, the political maneuverings of Mitch McConnell to get those 2 additional justices in there. So I think that would be one of the major controversies right now.
Well, I think that a lot of it comes from the fact that we are more divided as a people now than I think any time since the Civil War. And that division, as we said, the court is political, that it's got to get to the court too. And this is until recently, presidential nominations basically were rubber stamped. There wasn't a whole lot of.
What about work?
Well, by recently, I mean the last 60 years. Oh. Okay, I'm old, right, Paul? But until recently, they, and Nixon had some, but it's become more political.
Yes, I think both of them have given some good reasons. This court has been uniquely willing to overturn precedent. Precedent is this notion that you should look at what previous decisions have held and try and abide by them. And there's almost a little bit of an arrogance with that in terms of how they're just taking a wrecking ball to it. There's another thing that I don't think gets quite as much discussion about in the media, but I, as a political scientist, am a little bit worried about. This court is pretty willing to say no to the other two branches on a regular basis. And it's the least democratic of the branches, right? The other two branches are elected. This branch is appointed and confirmed. And I'll just try and give a quick illustration. There's a new doctrine on the court called the major questions doctrine. And to be quite blunt, I'm not quite sure where it came from. I mean, the justices point to a case in the 1890s and some more recent cases. But basically what this doctrine holds is that if bureaucratic agencies haven't been explicitly delegated by Congress that they can do something, then the court can determine that those agencies are not allowed to regulate. And this was used to overturn the Biden debt limit, the Biden debt relief proposal. The reason why I have a concern with that isn't necessarily because I believe in the debt relief. That's not an issue that I'm all that passionate about. But I think that there are other ways, if you're upset at Biden's use of executive authority, that the Constitution says we should proceed. And that's Congress should say no. The court is intervening in a political process that I think the framers would be much more comfortable having Congress make the decision. If Congress doesn't like what Biden is up to, they have oversight. They could actually pass a law that says that Biden can't do debt relief. But to be frank, I think the court just looks at Congress and says, well, it's ineffective. Well, they're not going to be able to do it. And so they've decided to take it upon themselves to declare that this is not an executive power. Perhaps there's some truth to that, but I would much prefer that an elected body make those decisions.
Thank you.
A couple things from Dr. Fletcher's thing that Robert's saying he's an umpire. Does that mean we're going to have an automated strike zone, have computers make the decision? And presidents appointing justices that tend to agree with them. Eisenhower said, in his words, the biggest GD mistake he ever made was appointing Earl Warren.
Excellent. Thank you. So, questions. Are there any questions? Yes.
So, it's accepted that elected officials and corporate money go hand in hand and have since the beginning of the United States. And I've always maybe naively looked at the Supreme Court as the safeguard for that, as the place where that doesn't happen. But with the recent scandals breaking out, Clarence Thomas specifically, is this a new thing in the Supreme Court, or is this a old thing? Has this been coming up for quite a while, or is this just something we're being more aware of now? Are there any historically significant cases like this where we're seeing
That's a great question. That's a great question.
manipulation,
Yeah.
outside money forces interfering with
No, I'm not aware of any, and if there were, they would have come up for impeachment. That would definitely be cause for impeachment. Now there may be some federal judges, so that's too low level for me. I'm up here in the clouds. I only look at the Supreme Court, but there are other courts, of course. So there may be federal judges that have had, and almost certainly have. Brian might know, but let's hand it over to Brian.
Oh, no, you keep talking.
Oh no. No.
Well, I think part of it too is, and reason no big deal's been made of it, is that the bar maybe overall has just been lowered. And we just expect that kind of thing from all politicians. Definition of politics from my colleague, Dr. Davis, politics, poly, many, ticks, blood-sucking organisms.
Yeah, so I think there have been some judges that have been removed for bribery issues, right? So that's something historically. I can't tell you which ones. That's not something I'm an expert on. But I think that also is one of the illustrations of how important the court has become in terms of basically a policy-making body. So I won't get too much into the details, but you were referring to Clarence Thomas and not disclosing some of the trips that he's been on. Republicans instantaneously rushed to his defense, not necessarily because I think they think it's a good thing that he didn't disclose it. I think privately most of them would say it should have been disclosed, but because there's no way they want Clarence Thomas to have to step down and be replaced by Joe Biden. And so it creates a situation in which you have to kind of defend behavior that isn't all that great because of how important each individual seat on the court is. And it's not just Clarence Thomas that's faced some issues. There are other justices. Sonia Sotomayor, for example, has been accused of hawking books. That's not necessarily something that you want your Supreme Court justices to be doing. And then Samuel Alito has faced some issues with that as well. I think that disclosure is something that they should be much more willing to engage in. And in fairness, the last set of disclosure reports, both Alito and Thomas actually did start listing some of the plane trips they've been taking.
Well, plus, maybe does the Congress not want to get involved in this because then are we going to expand this kind of thing to how many congressmen are accepting gifts and such? You know, that's not open that Pandora's box.
Yes.
So this is more towards, because now we're in the 21st century. I was wondering, now that the public, so before, if you weren't really interested in politics, you really didn't know about everything that was going on. But now with the expansion of social media, television, everything in like the 21st century that kind of blows everything out of proportion, do you think that has substantially, do you think that could be why either the court is overstepping their stay within cases that you previously mentioned, or do you think that is why Congress was more hesitant to kind of set out when it was talking about the debt relief with Joe Biden? Do you think that's why any decision could have been the way it did?
Would you repeat the question?
Sorry, I just kind of
We can do it on the mic.
Yeah, there you go. Yeah.
Yeah, no, you don't have the mic, so that's okay. The question is about the impact of social media on this, and has the evolution of social media contributed to all of the politicization we're talking about? I think that's the question. I think our political scientists, that's one for them.
Yeah, so I don't think that it's any surprise that the justices are going to be more polarized in an era that's more polarized. You wouldn't expect them to exist outside of that context. And both sides have actually put a premium on making sure that any justice they get onto the court is ideologically aligned with them. So, for example, I mentioned David Souter previously. David Souter was appointed by a Republican, and he ended up being a fairly liberal justice. And the saying in the Republican legal community was, "No more David Souters." We're going to ensure that going forward, that judges that get on the Supreme Court are going to be as ideologically conservative as the rest of the party. And to be fair, part of their jealousy about David Souter is they thought the Democrats had actually done a really good job with that. They did not have any David Souters. When they appointed justices, those justices, for the most part, were reliably liberal. If you look at the decisions of recent Supreme Court nominees, for the most part, they do fit into either a liberal or a conservative camp. And so I don't think that's a surprise in a polarized era that that's the way it would be. Is it a reflection of social media? Perhaps. It's also probably a reflection just of living in a more polarized age, and social media contributes to that. Does that kind of help a little bit, or?
How has social media kind of created that divide within members of Congress and within the court?
Yeah, that's a little bit harder for me to answer because I would be doing a lot of speculating based on what the justices. I mean, I do think that some of the decisions are reflecting more polarized age. What I mean by that is some of the language in the decisions is a little less respectful than it used to be. So, for example, when you dissent, you're supposed to say, "I respectfully dissent," and the respectfullys are occasionally being left off because of kind of the animus that's on the court. A big issue that happened last year was a Supreme Court opinion was leaked, a draft of it was, and that's a huge violation of Supreme Court protocol. And although we don't know who leaked it, I think the fact that it was leaked demonstrates that polarization isn't just limited to society. It's there on the courts as well. And I assume at some point we're going to hear some tell-all memoirs about how difficult that term was. Although Dobbs was the highlight of the term in terms of getting the most media coverage, there were several other very controversial cases that really divided the justices. And it wouldn't surprise me at all if we end up with some books that demonstrate that just like society as a whole is divided, that the court is as well.
I would just like to add to that. I think that I think people probably are studying the impact of social media, and what it seems to me is that it has heightened the performative aspect of politicians, and that goes right to what Professor Fletcher was saying there. But in the 1850s, that would be a even more hostile partisan era than we are now, if you can believe it. And the 1790s, I would put up along with our era too. There's no social media, but there is dissemination of ideas of what people are doing. So while social media has made it easier and perhaps broader, for example, now you can read a Supreme Court decision easily, whereas they weren't always published in newspapers, although sometimes they were. But people in the 1850s who were interested in politics were following exactly what was going on. Maybe not to the detail we have now. It didn't create this kind of performative opportunity that we see in the social media age. But I wouldn't dismiss the degree to which people were informed in the past. Newspapers existed and were plentiful. Most towns had 2 or more newspapers, even tiny little towns in the 19th century. So there was a broad dissemination of ideas before the social media age. I think we should keep that in mind. And so I think that I wouldn't blame social media for our hyper partisan divide. It may be inflaming it a little bit, but again, we've seen it in American history, and I think in more severe ways than now.
Yes, and maybe society as a whole has gotten less respectful. Would it be surprising if the court didn't also reflect that?
Yep, I agree. Question here.
First of all, I'd like to thank the members of the panel. I think you guys have done a super job. This is a very, very difficult subject, but I'd like to return to the idea of inappropriate compensation for members of the judicial community. Part of the difficulty of investigating this, if you look carefully at the behavior of our senators and a few of our representatives, especially those in power, I recently read a short statement that indicated that 7 of the wealthiest counties in the United States surround the city of D.C. The same article pointed out that D.C. does not sell software, it doesn't grow grain, hasn't built a car, and hasn't provided much other than access to power in the last 200 years. So the idea of selling our distributing influence through the use of compensation is not a new event. Thomas did not invent that. And I think one of the things that has weakened America's interest in government and actually has produced some cynicism is the fact that many of us believe that that has grown unchecked over the last couple of decades. And so no doubt Thomas' behavior would be in a sense of ethics probably inappropriate. However, in reference to by the way, I used to do a lot of lobbying in D.C., And in comparison to what I've visualized personally, Thomas is a small player.
Want to react to that?
Yeah, I guess I should say, when I was talking about Thomas, I actually don't think, even if he did go on those plane rides, that it influenced his decisions. I think his decisions would have been the exact same. I think his ideology has been fairly consistent for most of his term. I think that those plane trips aren't necessarily an example of him being bought off. I think it's just kind of a reward that he was able to participate in, but his decisions, I don't think, would have been any different absent those.
But there used to be a saying, Caesar's wife must be above reproach. You know, don't have any appearance of something like you were saying.
Yeah, I think that the early Republican theorists in Britain and in Europe elsewhere, one of the things they were mostly concerned about in a republic was corruption. And that is really where a lot of the separation of powers and checks and balances comes from, is that the belief that human beings are inherently inclined to become corrupt when powerful. And so I think that the framers, when the Constitution was written, they were still believers in the possibility of what the Romans called civic virtue, that people could put aside, Americans particularly could put aside their personal interests for the greater good. And then in the first decade, they learned that that was absolutely not true. And some of the framers believed that. Madison didn't believe that civic virtue was possible. But I think the framers built in some things that, for example, the Thomas situation or the corruption that Professor Galtney is mentioning, you know, there are processes for those. And impeachment is one, right? So, I mean, it's built. If it is corruption, then it's built into the system. What seems to me is that the legislative branch is so dysfunctional now, and that's for another presentation. That's for another time. But yeah, I don't think that's a problem with the design of the system at all, in my opinion. I think that corruption is always going to be there, and the system should be built in a way that builds in ways to root it out.
Well, and I think the number of impeachment proceedings against judges has far outnumbered the number against any other branch of the government.
Well, yeah, I think so. Go ahead.
I was just curious about what you guys would think the biggest hurdles in implementing term limits within the Supreme Court would be, because I feel like a lot of people agree that it's something that should happen, but no one really knows how we're going to get there. So I'm curious what your guys' ideas on that would be.
Well, I'll get us started. I'm sure the others have a phrase too, but really it's the amendment process, and the framers built in a very difficult amendment process of 3/4 of the states. And so that I think has been the log jam. And when the framers did that, they thought that was generous because they wanted it to be not too generous. But the previous system, the articles, had needed unanimous approval of the states for any changes. And they said, oh, that's terrible. We're going to make it 3/4. And they thought that was a reasonable number, and maybe it still is a reasonable number. But because the way the parties have shaken out, it's become almost impossible to get 3/4 of states to agree on anything. I think that'd be 38, right? I think my math is right there. So, I mean, is the sky blue? I don't think you can get 38 states to agree on that because of kind of our current hyper-polarization. If we look at the amendments to the U.S. Constitution, there were 27 in 200-plus years. The first 10 came in the first 4 years. So let's take those out. So that leaves 17. 2 of them contradict each other. So that, they're the prohibition ones. So they're just out. So that's really only 15 substantive changes in over 200+ years. So I think it might be easier as a reform, to change the amendment process to make it a little easier. Perhaps that might be your first step, because there do seem to be. I think the American public would agree on a number of changes, and I bet term limits for judges. For federal judges, I bet that would be really popular. I bet that one would take off. I'm not sure, but I think it would.
Well, also, I think people, if you ask the if you would have told the framers, hey, this is going to last over 200 years, they'd have said, you're nuts. I don't think they meant for it. Jefferson said a little revolution now and then is a good thing. And they didn't expect it to last this long, but I don't think the states would agree. I don't know if the states would agree to changing the amendment process. They'd look at that as a loss of power, maybe.
Yes, that's a great question. Advocates of term limits on the courts say that's probably true. You wouldn't be able to get an amendment, but they think you can do it via statute. So you could just do it via law.
Doesn't the Constitution say they serve on good behavior, so that?
Yes. So what you could do is you could set up a system where the justices, after they've reached 18 years, would have a senior status. And the Congress could regulate the jurisdiction that those senior status members would have. So, for example, they could regulate the judiciary, or they might have a limited jurisdiction. And Congress has changed the jurisdiction of the courts previously. And so I think both of my esteemed colleagues are absolutely correct. It's probably not going to happen through a constitutional amendment. I do think, though, that you could have a situation where Congress decides to go ahead and impose the term limits and abide by the constitutional provision that they will be there for good behavior. Interestingly enough, and I don't know if this is how we're going to conclude because I know we're running up against time, the body that would get to determine whether or not that statute was constitutional would be the Supreme Court. So they would get to decide whether or not some of them would become senior status judges or whether or not they would continue with the current path. I'd also just quickly add, I'm not sure, given the current composition of the court, that Republicans would be all that in favor of term limits right now. They certainly benefit from the status quo. At a future, in a future couple of decades from now, that may not be the case, and perhaps the situation would change. Democrats may not want to have term limits. You tend to like the system if it's currently on your side.
I don't want to belabor this, but I think you could construct it in a way to phase it in. So that way it would not hurt either party right now or hurt current sitting justices. That might be a way to get around that people voting against their personal interest.
Well, one more quick question.
What would be the main concerns of an 18-year term for judges?
You know, that's the first I've heard of this idea, and I kind of like it. I mean, I do think people live longer, not as much longer as people think they live longer, but I mean, definitely 10 years longer now. And I like the 18 years as, you know, it's 3 times the Senate term. It has a nice ring to it. Yeah, the problem is it's not constitutional, right? So how would you implement it? That's the problem. But I'm hearing it for the first time, and I like it a lot. I think it just solves a lot of problems.
Well, and the senior status, does that get back to Roosevelt's court packing?
No.
Or court reform?
Yeah, court reform.
Yes, I think they've highlighted a couple of issues. Some opponents to term limits make some additional complaints. One is that appointing Supreme Court justices is already a very partisan process that divides the country. You would have that twice a term, and they argue that it would just intensify polarization. I don't find that all that persuasive. Some people are worried that justices towards the end of their 18-year term will be thinking about not making good decisions, but whether or not decisions might benefit them in their next employment. And so there's the increased potential of corruption that both professors talked a little bit about. I think you could address that by restricting where they could go or providing some sort of emeritus status. But I don't think that it is not an idea without faults. I just think it would address some of the big issues we see with the current court.
And with that, if we could give a round of applause to a fabulous panel. And a very timely topic. As you are aware, this is recorded and it will be posted on the TMCC YouTube. If you want to share it with friends and family, maybe try to make it a virtual stocking stuffer. But we want to thank you for your time. Thank you for your time, and we'll look forward to seeing you in future programs of this year and at our next Constitutional Forum next fall.